you, everyone. Let's go ahead and get started. My name is Suzie now. I'm here, faculty here at Stanford, and I'll be moderating the first session of the second day. So here we'll have Danielle from UCLA present for 20 minutes, and that'll be followed by a 20-minute discussion by Regina from USC, and then I'll open up the floor for questions. So take it away, Danielle.
Thank you. Okay, so good morning, everybody. So I would like to thank the organizers and the theaters for inviting my paper, and of course to Regina for discussing it. So in terms of motivation, so to ensure an even playing field for all market participants, the SEC requires that firms disclose material information in a timely manner. However, the SEC gives firms some discretion in the sense that they can request that certain confidential information be redacted. For instance, firms very frequently request a redaction of their trade secrets. So the research questions that I'm looking at in my paper is like, first, do firms follow the SEC's confidential treatment protocols when they redact information? And second, what are the incentives that drive the redaction? And I look at this in the context of credit agreements, which is like one of the material contracts into which firms enter into. So before diving into my analysis, so let me just give you first an example of a contract that is SEC compliant, and then one that is not. So this is like the cover page of a contract that is compliant. So you can see that at the top, the firm clearly discloses that they submitted a request for confidential treatment. And here, a little bit lower, it also indicates that they redacted information and how you can find it. So in this particular case, you can find it by looking at a double star. So you can easily track the redactions as you go through the contract. So in contrast, here's a contract that is non-SEC compliant. So it doesn't disclose that information has been redacted or that the firm submitted a request for confidential treatment. However, as you go through the contract, you will find that certain information is missing. For instance, once you get to the fees that the borrower has to pay lenders, you will find out that they have like a separate agreement that is not disclosed. So in other words, if you're trying to figure out what the cost of financing is of this contract, you wouldn't be able to do that because important pricing information is missing. So let me give you a summary of my findings. So I find that most contracts in my sample are non-compliant. So 73% are redacted. However, only 1% have requested confidential treatment from the SEC. And this is like a big deal because it suggests that most firms redact information without SEC authorization and without informing market participants that they are doing that. So I also find that the reduction is driven by both lender and borrower incentives. So I find that when lenders invest more in monitoring the borrower, that they are more likely to get a reduction in compensation. And I also find that credit-constrained borrowers are more likely to redact their contracts because they want to avoid sending a negative signal to the market. So let me give you some institutional background. So I already mentioned before that the SEC allows firms to request that certain confidential information be redacted. So if firms decide to do that, they have to submit a request for confidential treatment. So they have to file the document on EDGAR in redacted form. Then, as I showed you before, based on the example, they have to indicate that they redacted information and how to find it. And they also need to disclose, they also need to explain why disclosure of the information is unnecessary for the protection of investors. So how do I classify debt contracts as redacted in the paper? So first, if the firm has requested confidential treatment, and second, I mean, if some fee information is missing. So why do I focus on fees? So I focus on fees, I mean, one, because they are material. So for instance, in a loan to classic cable, where fee information has been disclosed, the lenders charge the borrower almost 5% of the loan amount in fees. So thereby significantly increasing the cost of financing. So second, I mean, firms are not eligible for confidential treatment. So according to SEC guidelines, interest expenses in similar terms are not eligible for confidential treatment, even if they are confidential, but they need to be disclosed. Okay, so now let me get to my first prediction. So my first prediction is regarding the lender incentives to redact information. So lenders have incentives to redact information because they want to protect their profits. So on one side, they don't want other borrowers to learn about contract terms, or alternatively, they don't want other lenders to compete for the borrower. And my first prediction is that when lenders invest more in monitoring the borrower, they are more likely to get a reduction in compensation so that they can protect their profits. Okay, and here is an example that is consistent with the notion that lenders are trying to redact, have incentives to redact information. So this is like a confidential fee letter that probably by mistake was made public. In it, JP Morgan asked the borrower to not disclose the fee letter to anyone except to loan officers and if compelled in a judicial proceeding. Okay. So this is like a clear evidence that lenders are trying to hide pricing information. So my second prediction is about the borrower's incentives. So my second prediction is that when borrowers are credit constrained, that they are more likely to redact information because they want to avoid sending a negative signal to the market. So what is my research design? So consistent with prior literature, I used the covenant structure as my proxy for lender monitoring efforts. So I used the number of covenants and I used the complexity of the capital expenditure covenant. So in particular, I collect information about the CapEx covenant and I divide it in two types. So the first one is like a plain vanilla covenant that simply stipulates the maximum amount that the borrower can invest in a given year. And the idea is that this is a covenant that is easy to monitor or easier to monitor. And in contrast, we also have like monitoring intensive covenants, okay, which have additional provisions, like for example, a state contingent provision where investments are conditional on the performance of the borrower, and also carry forward provisions which allow the borrower to roll over any unused amounts. And the idea here is that these covenants require more monitoring. I mean, first, because lenders need to keep track of more stuff. And second, because they are more likely to lead to future renegotiation, precisely because they are more complex and therefore requiring additional lender effort. So here is an example of a plain vanilla covenant. So it's relatively easy to monitor. It simply stipulates the maximum amount that the borrower can invest in a given year. And here is an example of a monitoring intensive covenant. So in this case, investments are conditional on the performance of the borrower. And prior research by Christensen and Nikolaev suggests that covenants based on performance are more likely to be renegotiated in the future, therefore requiring additional lender monitoring efforts. So here's like another example of a monitoring intensive covenant. As you can see, it's pretty long. And at the end, it has like a rollover provision. So what are my proxies for credit constraints? So I use the excess loan spread relative to other loans in the same industry and whether the borrower has no credit rating. So what is my sample? So to keep hand collection manageable, so I read like every single contract. I focus on firms that have a CapEx covenant, which are more sensitive to monitoring needs. And that gives me a sample of a little bit more than 200 contracts. So after going over all these contracts, I find that 73% are redacted. However, only 1% have requested confidential treatment. And this suggests that most firms do not comply with the SEC's confidential treatment protocols. They redact information without authorization and without making market participants aware of that. So now let me show you some results about my first prediction. So I find that both proxies for lender monitoring are positively related with redaction. And in particular, in column 2, you can see that contracts with a monitoring intensive covenant are 12.7% more likely to have a redaction. So here are my results for my second prediction. So I find that both proxies for credit constraints are positively related with redaction. And in particular, in column 2, you can see that contracts with a non-rated borrower are 6.7% more likely to be redacted. So then I also conduct a test to get a better sense of whether lenders are trying to requesting redaction information because they are trying to hold up the borrower or because they want to hide information from other customers. So in column 1, I find that redaction is positively related with the same lead arranger arranging the next loan. However, in column 2 and 3, I find no relation with future loan spreads. And this result is like less consistent with lenders trying to hold up the borrower and more consistent with lenders trying to hide information from other borrowers that they have. So remember that at the beginning of the talk, I showed you an example of a contract that was non-SEC compliant, okay, that had missing fee information. So here's like a list of other information that is frequently redacted without SEC authorization. So I find that between 60 and 70% of contracts, they have missing information about the company and collateral. And then to a lesser extent, but still like quite frequently, they have missing information about litigation risk, compliance, investments, and loan terms. Okay. So just to conclude, so I find that most firms are non-compliant with the SEC's confidential treatment protocols. So they redact information without SEC authorization and without informing market participants that they are doing that. So I also find that lender and borrower incentives drive the redaction decision. And notably, I find evidence consistent with lenders requesting the redaction of important pricing information so that other borrowers cannot see it. Thank you very much.
I'll start before. All right. I would like to start by thanking conference organizers and Stanford faculty for a great conference and for an opportunity to discuss Daniel's work. So I think Daniel did a great job presenting his paper and summarizing main findings. So I will briefly reiterate the main findings, and then I will move to my comments and suggestions. So what is the motivation for the paper? Regulation SK requires firms to disclose all material agreements, and loan contracts are very often material for the firm. However, at the same time, firms can request permission from the SEC to redact sensitive information when this information relates to firm's competitive advantage. And all prior research is focused on equity markets or product market advantages or disadvantages, and we know very little about redaction of contracts in a context of that agreement. And this is exactly what Daniel is asking in his paper. And the main research question is, do firms follow the SEC protocols when redacting information from their credit agreements? And the main findings, as we just heard, yes, most firms violate SEC requirements, and especially this effect is more pronounced when there are incentives for borrowers or for lenders. In terms of borrowers, this happens primarily when borrowers are credit constrained. And in terms of lenders, it happens when lenders have monitoring efforts and try to be compensated for their monitoring efforts. And what is very interesting, lenders are not trying to hold up the borrower in Regina 92 cents, but they're trying to hide from other borrowers more favorable terms that they give some of their clients. So I think it's a very interesting research question, but I believe we need to put it a little bit more in the perspective of prior research, because prior research shows that redacting of information is not costless. So redacting information leads to the increase in information asymmetry and a cost of capital. Firms, in response, increase voluntary disclosure, but even increasing voluntary disclosure is not sufficient. It cannot offset reputation costs and increase in information asymmetry. So why firms do that? Why firms agree to bear more information asymmetry costs? Because they get to protect their competitive advantage. So I struggle a little bit how to put the reduction of information in that context in this setting, because it doesn't seem like reduction of fees and maybe some other information is related to competitive advantage in product markets, as other literature was saying. There's no evidence also that firms are compensated by a better covenant structure or low interest rates. And we also need to somehow incorporate in the paper shareholders. Like, why would shareholders agree to high information costs? Because it seems like the most benefit going to the lenders in this case. A little bit more on benefits, especially from the borrower perspective. The paper finds that most of the benefits go to credit constrained borrowers, and as a result, they have incentives to redact disclosure. However, prior literature has a very opposite finding, so it will be very interesting to reconcile, because prior literature shows that more credit constrained borrowers prefer higher disclosure or more voluntary disclosure, because this is how they can attract more lenders because they're credit constrained. What else I think is interesting in this setting is the idea is that borrowers are trying to hide high fees because it may signal to the market that they are too risky. However, unfortunately, because we don't see these fees, there's no evidence that they indeed hide high fees versus some other type of fees. And I struggle how to reconcile borrower and lender incentives, because as we just saw from the presentation, lender benefits are very different. Lenders prefer to withhold information about favorite fees. So lenders prefer other borrowers not to know about their low fees. However, borrowers are trying to hide high fees. So at the same time, we have incentives on the lender side, we have incentives on the borrower side, and they seem to be inconsistent, but we are talking about the same withholding, right? We withhold the same fee information. So I guess the paper it will be helpful if the paper reconciles a little bit more how they can coexist in the same setting. So I think it's very important to look at the mechanisms through which firms redact information to better understand why we focus on the fees. So the one option to redact information is to redact covenants, interest rate, or some other loan terms, and request SEC approval. This is coded as confidential treatment. Another option for companies to redact information is to report fee information in a separate document, mostly without SEC approval, as Daniel finds, and this is coded as missing fee information. So if you look at table 2, as we just saw in the presentation, confidential treatment is less than 1%. As a result, 71.9% are missing fee information without asking for confidential treatment. So the main variable of interest in a paper is equivalent to missing fee information without approval. And it's very important because of that to see what fees exist in syndicated loan contracts. And I think it will be great to add a little bit more discussion to the paper about the fees. So there are 5 primary fees that exist in syndicated loans. The first one is commitment fee, paid on undrawn or unused amount of revolving credit. The second one is facility fee, paid on a total amount of revolving credit. Another fee, utilization fee, also related to revolving credit. There's one type of fee that is common for institutional loans, term loans, if they're prepaid early. And the last but not least, very important, is upfront fee. This is the fee that is paid to the lead arranger for structuring and syndicating the contract. There's a very distinct difference between how the fees are reported. So the first 4 are always reported in a loan agreement. So they are part of the pricing reported in the credit agreement. The last one, which is upfront fee, is reported in confidential fee letter. So whatever was coded as missing fee information relates specifically to the upfront fees paid to the lead arranger. What are these fee letters? We saw one of them in Daniel's presentation, and this is indeed the only one exists. It probably was leaked by mistake. I was looking for them. They don't exist. It's the only example that I saw as well. So what are the fee letters? Fee letters include upfront fees, as well as some other fees that may be paid to the lead arranger. They also include something very interesting that I learned myself. I didn't know about it, including flex language, which is the right of the lead arranger to change contractual terms in case the lead arranger cannot close the syndication. For example, if demand is low, lead arranger has apparently the right to adjust covenants, amount, and interest rate. So a few more examples of confidential fee letters. The first one from 2013 at JP Morgan Chase. Agency letter may not be disclosed in whole or in part to any person or entity without our prior consent, and credit agreement between Citigroup and another borrower. Each of the fee letters are for your confidential use only, and that neither the existing nor the terms can be disclosed. So I know that Daniel interpreted this as lenders hiding information. My take is pretty different on this confidential letter. So what I did, I think this is the main question: are they indeed required to be reported to SEC? Because as we see from the letter or from the contract, contracting parties treat them as fully confidential. So I approached Loan Syndication and Trading Association. This is the main governance and leadership body in the syndicated loan market in the United States. And I talked to a few executives there, and I read a bunch of documents written by LSTA, especially the handbook of Loan Syndication Trading Associations, which is like a Bible to anybody who is doing that contracting. So what I infer from my discussions and reading the documents is that fee letters are not part of the loan agreement. And this is very important. They are separate documents. They are confidential agreements between the lead arranger and the borrower. They are not even disclosed to syndicate participants. Not just not filed with the SEC, they are not even available to participants in the syndicate. So the only lead arranger and the borrower can see the letter. And what is also very interesting, there's actually no requirement for the loan contract to reference fee letters, but they almost always exist. So I had to also contact SEC to reconfirm my findings. I informally contacted them, of course, not officially, and I spoke with an executive there, and an executive at SEC confirmed that SEC treats fee letters as separate from credit agreements. They are not part of the credit agreement. And for the letter to be required to be reported to the SEC, it by itself, without any relation to the contract, should be considered as a material agreement. And the conventional wisdom is that fee letters are not material agreements. So I conclude, at least my view, is that there's no requirements for the fee letters to be reported to the SEC. So what implication has to the research design and the research question, if I'm right? The redacted is our primary variable of interest. So in my view, it doesn't reflect violation with the SEC. I'm also not sure if it can capture information reduction for the following reason. So if it's missing fee information, is that when fees are not reported and a contract is referred to confidential letter, I agree with that. The problem is here. When there's no reference to the fee letter, the paper interprets that as fee information is not missing because, sorry, when contract does, because fee information, but however, as we saw in the previous slide, there's no requirement to mention in a contract anything about fee letters. And even if the fee letters are not mentioned in a contract, it doesn't mean they don't exist because upfront fees are almost always reported in the fee letters. So I think my advice, if I am right about institutional setting, will be to rephrase the research question. And what the research question in my view is asking is what factors can explain why contracting parties refer to fee letters in the contract and why and when and why they don't. And then we can rethink what we can learn from exploring this question. Some other institutional consideration that think, even if Daniel disagrees with my take on confidential fee letters, I think there's something else that we need to think in this context. First of all, SEC permits reduction of sensitive information when it has a competitive harm that could result from the disclosure. However, I find it hard to see how fees paid to the lead arranger for arranging the syndicate are related to any harm or competitive disadvantage. So I'm not even sure that you can request fee reduction from the SEC because it doesn't relate to any product market disadvantage. I would also be more careful in the paper with saying that interested parties are not aware of the information disadvantage, because the non-disclosure of upfront fees is well known in the market. It exists for years. This is very common practice. It's this information is widely known for loan market participants to investors and even to academics. It's listed in a few papers that upfront fees are not disclosed. And myself, many times reviewers ask me, okay, what about upfront fees? And I had to say, unfortunately, there's no information available. So I believe that if borrowers indeed need to report the fees, these sophisticated participants would ask for them by now, because if they know, they have to be reported. Also, I was a little bit surprised about the amount of violations, because as we know from prior research, almost all reduction requests are approved. So it's not clear what would be the reason to violate. And the last institutional comment, and I may be too optimistic here, I would expect SEC to realize that most of the companies in the United States are violating their requirements. And they had enough time to do that, at least 30 years, because the practice of confidential fee letters is out there probably from the beginning of syndicate market. But they still seems like, based on if you just purely interpret papers finding, SEC is missing that most companies are not reporting fees, violating, and not asking for any permission. Again, I may be too optimistic that SEC will figure it out. Okay, I have a few more minutes, 5 more minutes. I'll give a little bit empirical comments that may be helpful. So I think that we saw the paper is focused on a loans with CAPEX covenants. So I think it will be helpful to motivate a little bit more why CAPEX and not other covenants. CAPEX covenants are not as widely used as some other covenants. That EBITDA and interest expense exist in majority of contracts. CAPEX is only in around 30%. And also CAPEX is a little bit specific covenant because prior research finds that it primarily relates to firms when credit quality goes down or for leverage loans. So I guess it will be better if to justify why CAPEX. And I'm not sure that it's the most sensitive to agency issues covenants, because if we look at other income-driven covenants, they have very complicated structure, and performance pricing provisions can also have a very complicated grid. So a little bit more should be explained why CAPEX and not some other covenants and not performance pricing provisions. In terms of lenders' incentives, we already saw that it relates to the number of covenants and monitoring incentives, and the paper motivates that by monitoring efforts by the lead arrangers, and that they would like to be compensated for their monitoring efforts, and that it relates to hiding fees, favorable fees from the borrowers. Again, a little bit related to institutional setting, if 70% reduct, it means that in 70%, lenders charge low fees that they hide from others, and 30% of the borrowers are overcharged. So we need to think if it's feasible that 70% lenders are hiding and 30% are overcharging. Unfortunately, number of covenants and monitoring intensity relates to borrower riskiness, right? It's clear the higher number of covenants, the more risky the borrower is. It may be helpful to incorporate potentially the firm fixed effects if the sample is big enough to have a little bit of a control for firm characteristics. And most of the control variables in the regressions are justified by product market competition. So incorporating more specific debt contractual controls will be helpful. And yeah, as other proxies for monitoring intensive provisions, as I mentioned, there are also earnings-based covenants and performance provisions that can be used. So my main point about borrower incentives, as we saw, it's really borrowers are more incentivized to redact when they're more credit constrained. And my primary issue, as I said at the beginning of the presentation, is how to reconcile these incentives with lenders, because lenders are trying to hide low or favorable fees that they don't want some other borrowers to know. Borrowers try to hide high fees. So it seems like lenders and borrowers' incentives are not exactly aligned. So to summarize, is a very interesting paper. I enjoyed reading it. It forced me to think very about the institutional setting in this market, about all the specific issues and specific contracts that lenders issue. I didn't know much about fees and fee letters, so it was very interesting to read and approach SEC and LSTA to learn more. I think it's a very timely topic because surprisingly, syndicated loan market is not regulated. It provides more credit than equity market and bond market altogether, more financing than other two markets to US corporations, but it's still not regulated. I think people will benefit from better understanding and explaining institutional background about confidentiality, about the fee letters, that they are not part of the credit agreement, at least in my view, and that maybe it will lead to reassessing the research question and repositioning the research question so it's not related to SEC violations. And I think the paper still need to put the debt markets in the context of prior research, so that reduction we will also consider the cost of redacting information, not only the benefits, especially because prior research shows that redacting information is costly. This is probably true for any debt market paper. There are always concerns about homogeneity because everything is determined at the same time, but maybe firm fixed effect or something else will be helpful. And I hope that my suggestions are at least somewhat helpful, and best of luck with the paper. And I would like to, wanted to show you Tommy Trojan one more time and advertise USC. So thank you so much for opportunity to discuss, and I'm looking forward to Q&A.
Okay. Okay, thanks Daniel for a great presentation and Regina for a really nice discussion. So I'm going to put the floor for Q&A, but I'd like to start with a question from the online audience. So Xiali from Georgetown asked the following question. So it could be that some of the information is missing, not because firms are redacting, but just because that information is not available to the firm at the time the contracts are filed. For instance, the borrower and the lender might not have settled on some of the details. So the question really is, how much of your sample do you think reflects those instances, and how sensitive do you think your results are to excluding those contracts?
Yeah. So I mean, I think that these are like the final agreements that have been made public, and they do include like, I mean, they at that time, like the fees have been set.
I see.
Yeah.
Okay. So maybe we can start from Fiona.
Okay. My name is Shivakumar again, London Business School. I have a question which is, in fact, there are two sides to it, but they are related. And the first one is more about what should be the benchmark against which you're comparing all these companies as to whether they are redacting or not. Right now, you're comparing it against the rules, the regulation SK rules. But it seems much more that the standard should be what is actually enforced. And a very related point to that is maybe this is telling us not so much about what the companies are doing, but rather about what SEC is doing in terms of what is the standard it applies for enforcing these rules. Okay, and why this is becoming important is you can consider the example, an anecdote from what we see on the motorways, right? Motorways typically have a speed limit of 55 miles per hour. And if you ask me how many cars go at 55 miles per hour, probably less than 5%. And why is that? Because all of us know that the cops won't enforce anything until 60 miles. So everybody starts going at 60 or 65 miles. So showing then that, look, 90%, 95% of the cars are breaking the rules is not interesting. What is more interesting is if you can show me that 95% of the cars are breaking the rules even beyond what the cops are enforcing. So to that extent, it seems like, look, the benchmark itself must be to understand what is the level which SEC is enforcing, rather than just saying, is it verbatim rules that the SEC is trying to enforce?
Yeah. Yeah, I mean, I found like very, very little evidence that the SEC is enforcing this. I mean, I just saw like a few comment letters where they request the borrower to attach those, to amend the contract and to attach the missing information. But yeah, overall, I mean, there isn't much SEC enforcement. And I mean, related to that, I mean, you need to think that, I mean, the typical loan contract has between like 30 and 200 pages. And I mean, basically, in order to figure this out, I mean, you have to read like the whole contract. And besides that, I mean, the typical contract, I mean, talks about fees like 30 or 20 to 30 times. And it every time refers you to the next section. And then when you get to the last section, it tells you, no, actually, the fees have been agreed separately. And so, I mean, you really have to read like the full contract to figure out that that information is missing. Yeah.
Yeah, Atif Elahi, University of Utah. This is an interesting paper. So a question I have is about the sort of relative bargaining power of lenders and borrowers. So the paper is written from the borrower's perspective, but I think there's an opportunity here to bring in a lot more of the lender's incentives, and I kind of buy that part of the story as well. So I think one of the things that you could focus on is the syndicate structure itself and changes in the syndicate structure. So sort of give you some sort of variation in the relative bargaining power. So because it's a sort of a repeated game, and these loan packages can continue on. So every 5, 6, 7 years they could get renewed. So they might be shifting around who the lead arranger is. So I think there's some variation and richness in the data that you could exploit.
Yeah.
So I think that lender characteristics is something that I would like to see a little bit more of a push on, because the SEC might look away at the firms, but there's also sort of a indirect monitoring of the relationship vendors, so the banks. So maybe it's the SEC not necessarily not looking at the firms, but it's also, oh, well, this is sort of, we're regulating the banks anyway, and this, because this is bank-related disclosure, then maybe it's okay that they don't enforce it as heavily. So that's sort of the thinking I have in mind. Yeah, very interesting paper.
Yeah. No, thank you for the suggestion.
Good morning. Thanks, Daniel, for presenting, and thank you, Regina, for discussing. I'm Lydia. I'm a third-year PhD student here at Stanford. So take my comments with a grain of salt. So I guess the paper doesn't seem to explain why firms don't comply with the SEC confidential treatment approval protocols. And I might conjecture that this is because making it more salient that information is being redacted is in and of itself a negative signal, because non-disclosure in and of itself is potentially a negative signal. So I was wondering if, do you think this factor would interact with the predictions in your paper, especially whether lenders would take this factor into account in addition to your prediction that they would be more likely to request withholding information when they invest more in information production? Thank you.
So, can you please rephrase your question? I didn't fully understand it.
I guess it was just a very high level general idea that non-disclosure in and of itself could be a negative signal.
Yeah.
For example, there's a paper, it's not completely analogous to this one, but there's a paper by Amir Levy and Levine, I think. They study cybersecurity breaches, and basically if there is no disclosure about the cybersecurity breaches, then either a firm did not experience a cybersecurity breach, or they did experience a cybersecurity breach, but they were very big damages. So non-disclosure could, in and of itself, be a potentially negative signal. It's not completely analogous to this setting, but yeah, just a general idea.
Yeah. I mean, yeah, I agree that it could be like a negative signal, and probably because of that, they try to avoid going through this confidential treatment process, because the only way that you can find out that the information has been redacted is by actually going through the contract.
Yes, I agree. Thank you.
I'm Ayon Tan from Georgetown University. So I think I keep thinking about what's the unit the court, SEC, or the contracting parties use to determine materiality. So it sounds like the disagreement between you and the discussant is that you tend to think about the aggregated fee amount or the debt contract package as a whole is actually material. But I think Regina's kind of point of view is that individual document is the unit to determine materiality. So I think as a reader, I would like to kind of see you maybe survey or talk to people in the industry or from different sides, or even have some references from the court cases to see what's the commonly used unit in this setting, specific setting, to determine materiality. So like, are we talking about actually it's a violation, or it's actually just an immaterial document omitted from the filing?
Yeah, no, thank you for that question. So I also had like that concern. I mean, I think it's similar to what Regina was mentioning. So I had that concern that I was potentially missing something. So, I mean, the fee letters that I found, the confidential fee letters that I found, are like 100 basis points or more that they are charging the borrower. And I mean, and you can think that the typical loan spread that they charge the borrower is like a little bit less than 200 basis points. So, I mean, we can debate, I mean, how material it is, but it is probably like meaningful. And then second, regarding like talking to practitioners, I mean, I actually talked like I interviewed like probably like 5 lawyers that specialized in redacting these contracts, that specialized in arranging these contracts on behalf of lenders or borrowers. And I mean, the way that it works is that when they submit the term sheet to the borrower to arrange the loan, that term sheet typically includes like a right for the lender to review certain disclosures and to make potentially like a request to redact that certain information is not disclosed. So in the sense that I got from these interviews is that lenders have like a very strong incentive to not disclose the fees, because the way that you can think about this is that lenders make money with the loan spread, but then also they have the fees. And the fees are like they end up being like a significant portion of their profits. And they don't want other borrowers to learn about that so that they can keep like a higher profit for themselves. And then it is like pretty, so it is true that these fees are often not disclosed, but I mean, they are like a material part of the pricing of that particular loan. So once you include the fees, the cost of financing of that loan increases significantly. So therefore, I mean, if you're valuing this firm, the weighted average cost of capital, I mean, you don't have all the information about the weighted average cost of capital of this loan, of the firm.
Hello, Lisa from Columbia University. Very interesting descriptive paper. I have two comments here. The first one is actually related to the thing you just talked about. I agree with Regina. It could be like from the regulator SEC's perspective, it could be different. Just to give you a little bit analogy, in another setting, I study related to like investment banks fairness opinion providers. Their compensation, like fee, SEC also describe even zero compensation as material information. So, but I don't know whether it's a separate document, but it itself, like I can see like some compensation could be material information there. The second comment is actually related to your table 6 about company information. It says that like 69% of company information is redacted, and then your description, it sounds like you alluded to it's related to some like negative information, like some violation, environmental regulation, violation of labor disputes. I feel like that could be a little bit more descriptive than just one sentence description, because from reading it is like table, it could be viewed as maybe there are some substitute information somewhere else. That's why they are now disclosing information or redacting that information related to Regina's comment. Could be some separate document or something else. That made me think. So because in general, like company information doesn't sound like very, very competitive or proprietary information itself, but your one sentence description, it sounds like so. So it would be helpful to give more color to that. Thank you.
Yeah, I can like give like more color about that. I mean, it's often like compensation agreements that are like not disclosed, taxes, environmental concerns, like even labor disputes, stuff like that is in that,
I'm just curious whether you had any reaction to one of Regina's comments about the fact that the SEC virtually always approves these requests. As you might have seen from the slide, I have a paper in this area, not loan agreements, but other agreements. And that's what we find as well, that the requests are almost always approved. And I'm wondering whether you think there's some reason they didn't request it because they thought it would not be approved. And if so, why? Maybe that's part of the story in the background here.
Yeah. So, I mean, according to the SEC guidelines, so like interest expenses and related terms are not eligible for confidential treatment. So therefore, I mean, if they were to be submitted, they probably wouldn't be approved. So then the second thing is that, I mean, there's nothing proprietary about those fees in those letters. I mean, there's nothing like proprietary. It is just like a number we charge you, like, if you want to renegotiate the contract, you have to pay 70 basis points and stuff like that. So.
I think it's related to Mary's question. I think it will be good to differentiate and explain exactly which fees are redacted, because I think the only fees that are redacted are upfront fees paid to the lead arranger. Everything else, as far as I understand, is reported in a contract. So all the fees that you said about renegotiation and about revolvers and about term loans will be as part of the contract. They cannot be redacted. The only reduction is the direct fee from the borrower to the lead arranger. Everything else that relates to pricing, it's also part of the pricing, but it's separate because it's paid directly to the lead arranger. Everything else will be in a contract.
So, I mean, I looked at a few like confidential fee letters. So, I mean, they include like a variety of different fees, not just like the upfront fees. For example, in this one letter that I disclosed about JP Morgan, they disclosed like 3 different fees that amount to 150 basis points.
My guess would be most of these fees will be paid to the lead arranger. It may be administrative agent fee and collateral fee, but it still goes directly to the lead arranger. But we can talk more about it later.
Just to follow on, I guess when you talk about violating the SEC's confidential treatment protocols, that suggests that this contract or the information that they're not disclosing is material to the company, not necessarily to a particular loan agreement by itself. So you'd have to show, because that's what the SEC is worried about, material information to investors about the company as a whole. So it has to be material to the company, not just one of its loan agreements. And I wonder whether maybe that's an avenue to go down. Otherwise, it's not really violating the SEC's mandate.
Yeah. So yeah, I can. So thank you for that suggestion. I mean, I can try to provide like more evidence that it is it is potentially material information. Yeah. Thank you.
Okay, that wraps up this session. Thank you all for your good participation, and we'll resume at 10:05.